Hi, it's Robert Mendelson, Fractional CMO here in beautiful Montreal, welcoming you to another episode of the Fractional Pros Canada podcast. We're part of Fractional Pros Canada, the home for Canada's fractional community, and you can find us on Facebook. We bring you conversations about everything fractional that matters for fractional executives and businesses from coast to coast. Think of this as your go-to spot for real talk, practical wisdom, and strategies you can actually use, all without the corporate fluff and with plenty of Canadian content. Whether you're a fractional pro or a business in our great country of Canada and beyond, this conversation is for you. Grab your espresso and let's dive in. Welcome to the Fractional Pros Canada podcast. I'm your host and fractional CMO, Robert Mendelson, here in beautiful Montreal. Joining me today are two fractional C-suite leaders who operate at the heart of business growth and strategy. From the Toronto area, we have Peter Kattan, a fractional chief experience officer, otherwise known as a CXO. Over 15 years of experience scaling design teams at hyper-growth companies like, but not limited to, Yelp, who many people have heard of. And from Cambridge, Ontario, we have Ryan Tremblay, a fractional general counsel with a background in both law and engineering, who has guided tech companies through complex legal landscapes. Today's Fractional Pros Canada podcast is powered by Your CMO, the proven framework for fractional CMOs. Learn more at yourcmo.com. That's YORCMO.com. Peter and Ryan, welcome to the Fractional Pros Pod.
Thanks for having me.
Okay, so I'm going to start off with a confession here, okay? I initially had reached out to each of you to do two separate podcasts, one on the topic of fractional GC, general counsel, the other on topic of fractional CXO. Enter the magic of what happens when you try to do work in the middle of a vacation through South America with your son. And I say to my team, okay, both Peter and Ryan have confirmed they're interested. Please reach out and book them both for a podcast on August 27th today. And so here we are. But interestingly, I think this is going to be one of the most interesting pods that we've done to date, because we're going to be talking about both of your fields of expertise and how they intersect and interact with each other and sometimes come into conflict with each other, which happens a lot in many businesses. And I've lived through it in companies that I've worked for in past careers. So I think it's going to be quite interesting to get into this. So I think this could be a pleasant, a serendipitous mistake, as they say. So let's dig into this and talk about a little bit of how the world of legal and experience intersect. So first of all, let's just define lanes. So Peter, fractional CXO, you focus on transforming organizations using user-centered design, right? You're all about the user experience. Ryan, fractional GC, focused on, I'm assuming, deal speed, efficiency, pragmatic results, keeping the client out of court, out of litigation at just about any cost. So what's the core mission for both of you? And Peter, you can go first. When you join a new client, how do you see your mission?
Usually, when I meet with a new client, we start talking about some of the complications, some of the challenges that they are facing internally before understanding how their product is operating. So most of the problems that I notice is actually how teams collaborate with each other internally. So the teams that I work with or try to help are the product design and engineering. And in general, most of the organizations out there, they are either engineering-driven, product-driven, hardly design-driven. Maybe the only company out there is Airbnb. The CEO and founder comes from design background, so it's very user-centric driven. So the challenge that I notice is who wants to have the power in leading the product and the organization. I come in, I observe how teams operate and collaborate, and most of the time there is a lack of transparency, visibility on decision making, and I try to bring them together so each team understand when a decision is made, why is it made, and how does this impact all the teams, and how can they actually work together to facilitate some kind of a resolution or an outcome that helps everyone to work cohesively with velocity to produce solutions and features that will be implemented in products that will help their end user to use it faster, and that will generate more revenue, more adoption, and what have you.
Yeah, that's a really interesting point you bring up, that most founders are not coming from a design background, and that's pretty rare. You gave the Airbnb example. I'm sure there's a few others, but they're far and few between. Ryan, how many founders have you seen coming from a legal background?
Outside of like the law firm space and related services, very few. Usually have entrepreneurial people on product or engineering side that come up with something really cool, develop the product and run with it. And kind of where I step in, I presume this is a follow-up question to Peter, is
Hmm.
how do I see myself fitting in? Much like Peter, I'm focused on helping businesses scale. Quite often that's companies in like the 1 million to $20 million range. They're trying to scale their offerings to their clients, build up revenue, and maybe one day eventually look for an exit, whether that's an M&A transaction or otherwise. So where I fit into it, where a lot of companies come to me, is they want to increase deal speed to get that revenue in faster so they can continue to grow the business and eventually prepare for that exit. Where I try to help out is trying to streamline things. So I work really closely with the finance team, helping out, try to understand where the pain points are there, improving cash flow overall with the legal contractual terms, and all the while looking at risk from a big picture so that when it does come time for that exit, we haven't created any landmines in our company portfolio that would jeopardize the deal that would eventually happen.
Okay, and you said the word landmine, so great segue into moving the discussion to a little bit closer to how legal departments, legal teams, general counsels, and marketing slash user experience can clash and create explosions of their own. So Peter, let's tee this up. So if you uncover some groundbreaking idea that you know is going to improve user experience, it's going to increase whether it's conversion rates or engagement or revenue ultimately. What's your process for bringing that kind of idea forward and getting it approved and live in the organization?
Absolutely. So, as a fractional consultant, my role is to empower the team to find the right way to do research and understand the needs of their customers and bring some data of their performance for their product to light. So they can have conversations around how can we pivot, how can we improve, what's next for us to iterate on the product itself and introduce new solutions and features to bump that kind of uh, revenue up or adoption, so to speak. So the most important thing is to empower and help the internal team again to work together and find and kind of link the puzzles together. So the product team looks into data. The engineering team will look into if there are bugs in the products that are impacting users going from point A to point Z. The design team will usually go in the field, do some research, talk to customers, do discoveries to understand really their needs and their pain points, and what are the things that are they struggling with in getting the job done. And if those three parties can get together and bring in their findings and discuss those together, then they will be able to work together to get to a resolution. My role as a fractional most of the time will be to facilitate some kind of workshops or brainstorm sessions and bringing those teams to understand what each one is required from them to do, so they can go in the world and do that research, come back with their findings, and then kind of converge back and discuss how are we going to move forward and improving our product.
Okay, so you bring all these, you facilitate all these great ideas to come together, get a few departments working on it. Maybe it's product, maybe it's marketing, engineering, maybe a couple other departments. And then at some point, somebody says, oh, we should pass this by Ryan in the legal department to make sure that everything's okay with them. So Ryan, pick up the ball there. What happens? A new feature idea comes across your desk, so to speak. What's the first legal or risk-related question that you're thinking about regarding this idea, and how do you treat it? And then what would happen from there?
So great question and incredibly timely. This literally came up with one of my clients over the last week or two. So they're coming to market with a brand new product offering. They work with somebody like Peter to develop it, have a great idea, really great product market fit, and they're ready to launch in like a week and a half. They come to me and say, hey, anything we should be thinking about this? And I say, the number one thing you should be thinking about is whether or not there is eligibility for IP protection, intellectual property protection. And have you guys thought about patents, trademarks, industrial designs, copyrights, any of these yet? And you're like, oh my God, what are all these things and what do I need to worry about? So in
This
those
is 10 days before
circumstances,
launch, right?
so one of the things that comes up most often in those is, well, we're launching in a week and a half. Can we do anything now? And the short answer is yes, but you haven't got much time. In most countries in the world, you have to file for IP rights, specifically patent and design rights, before you publicly disclose or sell your new product offering. So going back to working with Peter and all the teams, I find probably the number one thing I like to do when I join companies is let them know about this, so you don't have that week and a half blitz at the very end where you've got to put everything together and get something on file with the government patent office. So lots of training, especially at the C-suite level, making sure everybody understands that. So they're thinking about it during the early phases of discussion with Peter rather than at the product launch date.
So
Absolutely.
how does that work? Let's dig into that, Ryan. So you get a new client, and do you do some kind of like I don't know, a workshop presentation to other departments when you come in and say, hey guys, FYI, heads up, if you're thinking about any kind of new releases, changes, et cetera, these are the things you need to be thinking about. Is that kind of the thing that you do?
So I typically work with the CFOs on these types of things. So I'll do like a lot of one-on-ones with them, let them know the overview, the hot button issues that typically come up. I think I'd reevaluate how I do that and make sure we get a broader audience, including the CEO and other key stakeholders, especially on the engineering and product side, to ensure that they're aware of those things. But yeah, another area that comes up often as well, because Peter mentioned creating products with lots of great data insights. Quite often, people are collecting information about their customers and their profiles and how they're actually setting things up. Another problem I often see is the privacy landscape, which has taken off dramatically since GDPR launched in 2018, and other organizations around the world have set, or countries around the world have set up similar legislation. And people need to be aware of it. And when you're using data to create your products, you not only need to be aware of the privacy aspects, that you have the right to use that personal information, but also the insights gained from their own product use to develop your new offerings. You need to ensure that you've got those rights. And that also is another IP question. Quite often you refer to it as feedback rights from your clientele, and ensuring that you own all the rights related to new products and inventions resulting from that feedback.
Now, I've sat in the chair of, product manager, director of product, product marketing manager in different companies over the years, and I think Peter can probably support me on this. Whenever somebody says the word legal in any capacity, eyes roll. People just go, oh, it's just that, right? So, Peter, um, tell me what does it look like from your end when this kind of scenario that Ryan has brought up, this real life example, happens?
That's a really interesting topic because usually, and this is my experience when I used to work full time in the past, uh, most of the time people are so busy trying to figure out what is the next thing that they are doing, and legal is the last of their concerns. And most of the time, when we are about to launch something, they ask, "Did you run this by legal?" And as Ryan mentioned, it's most of the time too late. And we have to either delay launching something or launch a small piece of it to give our customers a taste uh, while we're working out the logistics and the legal stuff behind it. But then obviously I learned from that lesson. So now when I consult with organizations, while they are thinking in the beginning of something, a new solution, a new offering, I'm like, did you run that by legal? Did you check if we can proceed with this? So they are prepared in advance while and consult with legal while they are working on it. And so when the product is ready or the feature is ready, legal is ready, go to market strategy is ready, everyone is aligned. So now we can launch and everyone is happy.
So a few years ago, I was leading a digital transformation product. It was for a financial institution and on their retail lending side. So this is an alternate lender. If you couldn't get a loan at one of the big banks, you'd go to this company to get a loan. And when I came on the scene, the process for the potential customer to apply for a loan was extremely paper intensive and long. And so, as part of the digital transformation process, not only do we look at, all right, how do we make this digital, get rid of the paper, we also looked at how do we shorten the process. So, the process, of course, it goes through a billion questions that we were asking the customer. And so, it got to the point where, after we asked ourselves, why are we asking the customer for this information? Is it used by anybody? Does it really matter? Is there a legal reason? We end up having a lot of conversations with legal, and we ended up cutting, I don't know, 75% of the questions that were being asked because we say to legal, why are we asking this question? And legal would say, well, that's to protect us from X, Y, and Z. And, then the question is, well, what would happen if we didn't ask that question? And ultimately, there was a big negotiation, and ultimately, we were able to get that number of questions down. So, everybody was like, oh, those legal people, they just, covering their asses, and it's too much. And they always get in the way of user experience. Ryan, what do you think of that?
I think there's a lot of merit to that because a lot of lawyers can be that way. They're fearful of what could happen. And where I look at it is, yes, that could happen, but how big of a risk is it? And I always look at things from like a graph where you've got, risk level on the vertical axis, and then you've got potential impact on the other axis. And you want to look out for the things where there is a high impact and high potential of something happening. But if something is a low potential of happening something and low impact, it's not something you need to worry about very often, and you've got to move on next. So my focus is always looking on those big ticket items like the company issues. We talked about scaling to the point where you've got some sort of exit event. Is there something that's going to jeopardize that? Or is there something where we could have a lawsuit that would bankrupt the company? And that's the stuff I want to focus on. I don't want to focus on the things like, well, somebody is inputting their name into their tool where they're already our customer. Do we need to worry about that? No, we just need to hold their name, moderately securely. Let's move on next. If it's financial data and information where we're asking about, their passwords to their bank accounts, that's a different risk level where we've got to be more cautious and more careful how we approach things.
Peter, anything you want to add to that ball of
I agree with Ryan. I
confusion?
think, sorry, say that again.
Go. I said, anything you want to add to that ball of confusion, which it can be in
Oh,
many cases.
um, well, I agree with Ryan. I think it's very important to focus on the big picture and worry about the things that are very risky. Uh, Other than that, I came across scenarios where we are really pushing for a, a feature to collect customers' data, and this is the core of the solution. And if we can't collect customer data for some reason because of compliance or what have you, then really the whole thing is just not going to fly. Uh, there is a lot of back and forth with that, and there is a way to negotiate and try to figure out what is acceptable, so we can launch something and we can still collect the data that is required. So the outcome that we want that we desire is actually achievable. Um, so I guess negotiation always is the key to understand really what's doable and what's not.
All right, let's move on to the topic of the day, which is AI, of course. So, Peter, from an experience and design perspective, where are you seeing the biggest opportunities for using AI in what you do with clients right now?
AI is bringing a lot of interesting ways of working between teams. Design function, for example, are using AI in building interfaces uh, in a very rapid way. For example, back in the day when the design team or the organization overall wants to understand if a new feature or solution or an offering will work or will have adoption, takes time because you need to design it, you need to build it, you need to ship it, and then you start to collect data. Nowadays with AI, you can build something in a matter of a day or two, and and when you build that with AI, engineering team can just copy the code, implement it, and you can create a rapid prototype, test and validate with your customers in a matter of days as well, and that will give you a full understanding right away whether something has a market fit or not. Uh, that was not achievable a year and a half ago or 2 years ago. Uh, and the I see even the collaboration has increased a lot between the internal team, how they collaborate with each other. If the product team has the right requirements to what the outcome they desire to work with the designers. The designers can whip up something quickly with AI. Engineering can copy the code and implement it. You're saving a work of like 6 months or in months in general that can be done in a matter of a week.
So we're speeding up the amount of time it takes for new changes to get in front of Ryan. And then Ryan's looking at this and, wow, there's this whole AI thing. This opens up a whole new Pandora's box of potential legal challenges and risks. So, Ryan, what are those looking like these days? And I would imagine there's a lot around data privacy, ownership of AI generated content, those kinds of issues. What's happening in your world?
You hit the nail on the head. Those are two of the biggest topics that we see. On the privacy side, when you're putting things into AI frameworks like OpenAI or Microsoft Azure, you want to ensure that that customer data is in a closed environment. So you've got to use some of the private systems that they have set up rather than the open public systems where that data can be used to train the general models. A lot of the customers are actually mandating this across the board when they find out we're using AI features is they want to ensure that their data is not going out into the random ether for everybody else. Um, so that's probably topic one. The next one you mentioned is the IP ownership stuff. It's a weird space, and I would be lying to myself if I knew it really well, but when you're pulling in information from other outside sources and you're putting your own intellect into that, and then it creates something new, it becomes a really weird question of who owns that outputted data. Now, the AI systems around the world all say that you own your input data, but the output models vary depending on what terms and conditions you have for the exact provider that you're using. So you really want to be careful of what that ownership structure looks like when you're relying on them for product development features. Again, a lot of the private ones where you sign up and set up a premium or business style account, you get those protections where you will own the output, but you want to double check that. The last piece that you didn't mention that's really interesting, it's less of an issue now, but it's still on the top of the radar for a lot of people, is hallucinations. When AI gets it wrong, who's at fault for that? And a lot of the times it becomes a finger pointing game. You look at those old Spider-Man comics where you've got the three Spider-Mans pointing the fingers at each other, and it's the customer pointing the finger at us, the provider, and us pointing the finger at the AI solution that we're using. And it becomes a really interesting question whose responsibility it is. Now, one of the things I like to do is in my customer contracts, I like to set up a framework where they can choose whether or not they use AI tools that output to their environment for their own usage. And they have to toggle a button to say that they acknowledge they're using AI and they're responsible for monitoring the outputs of that AI. So it becomes a little bit of a system where they've got to be a parental figure and watch over the AI systems. So that helps limit risk a little bit, but not every client is willing to do that at the same time. They pay big fees for our services and they want to ensure that we're responsible for them. So you've just got to be careful there and how you manage that risk, often with a limitation of liability or something like that.
And Ryan, which AI do you use to draft your agreements?
So I actually use a couple different tools. I have a subscription to a legal provider to get templates, and then when I'm actually using legal tools to draft and edit contracts, I use specialized resources that are specifically made for lawyers. There's a couple different ones out there. I don't want to promote one particular one. There's one called GC.ai, which is great. There's another one called Contract Pod AI. There's a lot of options out there.
So that's great lead into it, to the topic of the double-edged sword of AI. You know, there's companies out there, there's CEOs out there who are like, I don't need a legal department anymore. I've got, GPT-5 or Claude. So how do you, what do you say to those executives out there who think that the need for an actual human legal counsel is diminishing quickly?
I don't think that is necessarily accurate. Remember how I just mentioned about the hallucination issue and making sure you've got a parent overseeing it? A lot of CFOs and CEOs think they can do it, but they don't know what they don't know in the legal sphere. Having somebody who's practiced and seen that stuff before can look at the output from an AI generated legal solution and spot potential issues in what they've done. Even within the legal community, we're seeing problems crop up where litigators are using AI to write their legal arguments, and AI is creating cases out of thin air that don't actually exist that they're trying to rely on. And you need to have an expert in the field to judge when that type of stuff is happening. Otherwise, again, you're leading into those landmines that are scattered across the field of your company that could potentially jeopardize something later on.
And Peter, you're fractional as well. You focus on elevating design. You're a fractional strategic partner at the leadership table. So what happens, or what would you say to a business owner who's listening to this? Maybe it's a CMO in a company, a full-time CMO, who's thinking, well, I don't need Peter anymore. I've got AI in my pocket. It comes up with all kinds of great design ideas. What Peter's out of business.
It's hard for me to kind of answer this, because I think in general, yes, there are a lot of founders or CEOs who are trying to just use AI tools to come up with the design, for example. But at the same time, I guess the only issue that they don't have in mind or think of is the design that they are outputting or producing is not bringing any value to the customers if there is no understanding of what is the value prop for a product that you're outputting out of AI without having a real expert with a lot of experience understand what works and what doesn't. Um, as simple as where to put a call to action on a website or on a product that will actually generate, signups. Um, it's it's easy to go and mimic and copy what's out there. Uh, but I think my expertise comes in not just as someone who look at a design and say, this is good, this is not, is to think of the full strategy behind it, which sometimes founders or CEOs think of the now versus let's say, the three horizon, the North Star vision, or where do I want to get to in 5 years from now. My role is to lead them through that, help them to understand what's your North Star vision, what's your three horizon, what do you want to achieve in 5 years, and let's work backward from there to figure out what are the right offerings that you want to start with now, and let's design that platform or website for that, and then have that North Star in mind. So as you are iterating on your product, you move from an MVP to phase 1, phase 2 of the product. You know what you're adding and when is the right time to add those features and solutions to build up on your offerings. And these are the things that, not all founders can think of that right away and have the right people to help them with that. They could have people to help them on the product strategy side of things, but then that has to be translated to the user experience and what's the user journey throughout your product as your product evolve over the years. And that's where I come in.
Yeah, and I love AI prompts to start with. Act as a human. When you have a bunch of humans sitting around who you can actually ask because they are human, it gets a little nutso over there. Ryan, as a fractional GC, what's your value proposition to a company that maybe either has a full-time general counsel and is looking at, their bottom line of like, wow, we're paying this person a lot of money and they're not working full-time, or it's a company that is in need of a GC but isn't big enough to hire a full-time one yet, and they're thinking about a fractional GC, or maybe they don't even know that's a thing. What do you say to them? How do you present to them with how you add value? And is it the same value that you bring as a full-time GC would, but on a fractional basis?
Good question. So there's two scenarios that you mentioned. The one where they have an existing GC, I'll touch on that lightly because I think a GC can be worth a lot if they're really good at understanding business and merging that with the legal landscape. Trying to find those individuals is hard because we're trained as lawyers to be really risk adverse and not business forward. So trying to find that individual who can balance those two topics is incredibly valuable. If you found that person, ride with them because they're going to help accelerate your business across the board. That's what I do. That's what I pride myself on. And that's how I help a lot of my clients. In terms of the companies that don't have a GC yet, it becomes a little bit more nuanced depending on the types of problems that they're doing. In a lot of SaaS businesses is how do we scale? How do we get to do things faster, better, to bring more customers on board? And that's streamlining the legal process where a CFO might have already set up contracts and processes to do things. Maybe that's not the most efficient way of doing things. Depending if your customers are small customers, large customers, or enterprise customers, there's different ways to approach those scenarios depending on the type of individual you're dealing with. And then last but not least, if they're getting ready for an exit later on, setting that stuff up now helps out immensely because if you try to do it when you're in the deal process, it becomes really complicated. It distracts from actually getting the deal done and can potentially scuttle the ship if you find one of those landmines along the way that is really important to your potential acquirer. You don't want to find that out in the 11th hour.
Fail to plan, plan to fail.
Exactly.
As the saying goes, one of my favorites. Peter, what's a user experience principle that you find is most commonly misunderstood or misapplied by growing companies?
I would say simplicity is key. Don't overcomplicate things. Don't over-explain to customers. People don't read. But people want something that just works and works right away. And the principle that I have in mind comes from there is a something you can find online. It's about MVPs. Well, an MVP is a minimal viable product, right? However, most of the time when we think about it from a design perspective, is we call is a different acronym, which is LVP, which is it LVP? Lovable, minimal lovable product, MLP.
Minimum
Uh,
lovable product?
yes, and I
Lovable.
say lovable because you can't push to the world something that is half finished. And sometimes organizations, unfortunately, think of an MVP as something that we'll just ship the first version of that, but then does your first version actually works? Um, when we think about it as a lovable, you want to make sure that it works and people love it so they can continue to use it. Um, so a great example is when you want to ship an MVP, you need to think of shipping a skateboard. The next generation of that or next version of that will be a bicycle, then a motorcycle, then a car. However, some organizations would ship uh, a bicycle, but with one wheel. That's not going to take you from point A to point B. Then therefore your experience is going to be broken, meaning your customers will start to use your product. They get stuck somewhere because of a bug or because the feature is incomplete, and therefore they can't get to the finish line. And that's not going to complete the job for them. And then what I try to do most of the time is to educate the partners or the people that I work with within the organization that I'm hired to help, is to understand that kind of principle and make sure it works. You don't get your customers stuck, because if they don't get to the finish line, you're not going to get your revenue.
I will just add that I have seen people on the streets of downtown Montreal riding on a unicycle. So sometimes if you ship the bicycle with one wheel, it may still work. But I have not seen a lot of people doing that. So I think your point is still valid. And I will also, it reminded me of I don't know if you guys are old enough to remember, there was a comic strip called BC, and it was all about caveman stuff. And there was one that really always stood out with me, and the panel of comics is basically one of the guys says, "Hey, look, I invented the wheel," and they show what we would recognize as a wheel, and then the next panel is the way he's trying to use it. Instead of rolling it, he's trying to flip it over, right? And he goes, doesn't work. Back to the drawing board. So it always stuck with me, and I think from a product design and user experience point of view, it's very relevant, because sometimes companies will come up with a great product and they don't even realize what the right way is to use it until they get the user feedback on it. It's kind of like shipping a one-wheel bicycle and then getting feedback from users saying, "Yeah, this is good, but if you added another wheel, it'd be a heck of a lot easier."
Absolutely.
Ryan, I got a question for you, and this is something that's always bugged me. There's, especially online, you're buying something, and it's like agree to the privacy and consent, and there's little links to both, which nobody ever clicks on, but if they did, they'd get to multi-page documents on the website with all kinds of legal jargon, et cetera, et cetera. So, I mean, the short question is, why do we need to have those if nobody's going to read them? From a usability perspective, they make absolutely no sense. And I would imagine the percent of people who actually do read all that stuff is 1% or less. So what's the story on that? And What can we do about it to make the world a better place for users from that perspective and still have companies comply?
Yeah, so you hit the nail on the head again. The key requirement there is comply. So you've got to comply with legislation all around the world for different products, whether it's software, manufactured, consumer goods, or otherwise. So those terms and conditions you see on websites are based on that and trying to limit the risk of the organization at the end of the day. So they're incredibly important for the organization, but it comes down to, does the individual consumer or user actually have informed consent on those things? Did they actually know what they're signing up to during the process? So how do we make it better for everybody? I think a lot of lawyers would do themselves justice if they stopped writing in legalese and they started writing in plain speak English. Now, the documents are still going to be long and cumbersome, but they're easier for lay people to understand and know what they're getting themselves into. If you ever did go to court, a court and a judge is going to look at it and say, did the person know what they were signing up to? And having it in plain English is a great start.
Okay, so let's say I come across, 5 pages of consent, terms and conditions. They're in plain English. I'm still not going to read them because I can just feed it into my AI, say, hey, please summarize this for me. Summarize it. I read the 1-paragraph summary. I go, sounds good to me. Click. Is that consent?
If they click consent, if they toggle a button, something along those lines where they've actually expressly shown that they have accepted terms and conditions, how they got to that acceptance doesn't really matter at the end of the day. As long as you record it as an organization and ensure that you have a tracking, it's going to help you later on if you ever do have litigation of any sort or regulatory investigation.
And from a consumer perspective, if I do that instead of reading the 5 pages, am I putting myself at a lot of risk or like minimal risk, or is it minimal lovable risk?
That you have to judge for yourself as a consumer what level of risk appetite you're willing to take, the same way that the business need to decide what level of risk appetite they're willing to accept. Whatever way you feel like you can get to the end result, go with it.
All right. And Ryan, what's the most common legal issue in your experience that you see startups, maybe especially tech startups, tend to overlook until it's too late?
I would say if you're going to say too late, it's the IP risk or IP. I'm not going to say IP risk. It's the IP blunder, if you will, where they create something new and they don't think about it until they put it on the market and sold it. And then they come later on when they're getting ready to do an exit, be like, this is my cool product. Can I get IP protection for it? And it's too late. That's not to say you always go for IP protection, get a registered patent or something like that, but you need to be aware of the option and make an informed decision on how you want to proceed, because it could be the crown jewels at the end of the day during an exit, or it could be worthless. You just need to make that decision.
Peter, from a UX perspective, from a CXO perspective, what message would you put on a billboard for millions of business owners to see as they drive by it on the highway of life every day?
Oh, that's a tough one. I wanted to comment something first about what Ryan said regarding the privacy policy and all of that, and I'll get to this. One common practice I started to implement a lot with organizations, and this is based on what I'm seeing online, companies are doing, is to minimize that privacy policy and terms and conditions that we ask people to sign on, and highlight the most critical thing in those. So make sure if you want to include something, make it short, make it just concise, 3-4 bullet points, informing them what are the critical stuff that they are signing on, and then if they want to read more, there's a link where they can expand and read the full privacy policy and terms and conditions. With that, you're making it a lot easier for customers to actually really open it and read it.
All right, well, Ryan, over to you.
And understand what they are signing.
What message would you put on a billboard for millions of business
you're still
owners
compliant
to see as they drive
because
by
you're showing them
every day
most
on the highway
important
of life
things that they need to sign.
Focus on the big stuff.
And again, if
don't
you
sweat
remember
the
what
small
I said
stuff.
before, I said make it simple.
Keep driving the business forward.
plain English, simple language.
The
That will
idea
help a
there
lot for
is
customers to
a
understand
lot of
what
legal
they are signing on.
professionals can sweat the
I think
small
that's the
stuff. They
key.
worry about whether or not
In
the
terms
correct
of
grammar is in a
what
contract.
to put
That
on a
doesn't matter
billboard,
at the
if
end
you
of the
can
day.
repeat the
Things
question
like
again,
limitations
sorry.
of liability, IP ownership, privacy risk, that's the big stuff you need to be focused on quite often.
Okay, and just to pick up on the point that Peter was making before he dropped off, are you okay with that as general counsel to
Looks like we have some
highlight,
technical
bold
difficulties.
the most salient points of all those terms and conditions that somebody needs to be aware of? Is that a good practice, or could that be seen as misleading because somebody can come back and argue, well, you highlighted these points to me, but these other ones that you're now coming back to me and saying, because I agreed to this, my warranty's no good. Is that okay?
So we already do that a lot in the legal world. If you've ever looked at terms and conditions before, there's often sections that are in bold-faced all caps font. I don't like all caps because I find it actually harder to read, but you specifically call out things like limitations on warranty, where you're saying the product is as is, or the liability is limited to some significant extent, or that you're selecting a particular jurisdiction for courts. Those are often bolded already. So we already do it. The other point he was mentioning is on the privacy stuff. You try to highlight the key things. So if you're doing a privacy consent, quite often what I've seen is you'll have a couple different toggle options. Like, I'm only going to allow the minimum amount of cookies. I'm going to allow us to sell your data to other third parties. There's a toggle for that. Or I am going to allow you to store my sensitive personal information around my financial data. They'll have those things as selectable options. And I think that drives more informed consent for the consumers and will help you later on. The problem that I have seen in a couple instances where that list gets too big and cumbersome and you can't figure out which options you actually need. The great example of this is the Facebook privacy page. I think that's one of the biggest blunders I've ever seen, or maybe it was, structured confusion from their legal counsel. If we make this so convoluted that nobody can understand what they're doing, we'll actually protect ourselves even more. I'm not sure if that'll actually help stand up, but I would advise against doing that because I see it as being risky.
Yeah, and as a user, I would advise against doing that because it's an awful user experience and it just damages your brand at the end of the day. All right, great convo. Ryan, how can people connect with you?
Easiest way is on LinkedIn. I'm on there all the time and ready to help out in any way I can.
All right, thanks so much for joining us today, Ryan. Thank you, Peter and Absentia. We'll get your contact details in the show notes. No worries. And thanks again to both of you for joining us today on the Fractional Pros Canada podcast.
Take care, Robert.
That's a wrap on another episode of the Fractional Pros Canada podcast. If you're a fractional professional based in Canada, we'd love to have you join us in the Fractional Pros Canada Facebook group, the home for Canada's fractional community. It's where Canadian fractional executives connect, share insights, and help each other succeed. Until next time, I'm Robert Mendelson, Fractional CMO. May your impact be full-time, even if your hours are fractional.